I do want to welcome everyone in to our 2025 Mid-Year Labor Law Update webinar. Today is sponsored by our partners over at the City of Glendale, who you will hear from in just a moment. My name's Anna. I'm the digital media and event strategist here at the California Employers Association. And again, we just want to thank you for taking time out of your surely busy day to join us for training today. Before we get into today's content, I have just a couple details to go over with you, especially if this is your first time joining us. So as you see, your audio is muted for today's presentation, but as you're already doing so in the chat, there are going to be lots of opportunities to engage during the training, and we really encourage you to do so. If you do have any questions about the content, you can put those into the Q&A box at any time, and we will do our best to address those as we go. While one trainer is delivering the content, the other one will be watching that Q&A for you, so you are going to be covered the whole time. Handouts will be dropped into the chat box shortly, so once you see that PDF icon and file name pop up, you can just click on it, and it should download locally to your drive. And I'll be watching that chat box, so if you have any issues accessing that PDF, you can just ping me in the chat and I'm more than happy to help you out. As you saw when you logged on, this webinar is being recorded and the team over at City of Glendale will be reaching out when that's available for review. So make sure you are active on their email list. And then last but not least, we'll be inviting you to share your feedback at the end of today's training by participating in a very brief survey. It's 5 questions and it generally takes about a minute to complete, but the feedback that you share with us in those 5 questions, we really do take to heart here at CEA. We share that feedback with our partners over at Glendale, and we collectively make sure that we are meeting and hopefully exceeding your expectations with trainings like this. And this is also your opportunity to share topics that you'd like to hear about for trainings in the future. So we really encourage you to scan the QR code at the slide at the end of today. I'll also be dropping a hyperlink into the chat for your convenience. And again, our training today is brought to you by our partners over at City of Glendale. Today, we are so happy to be joined by Sevik Deshoyan, the Economic Development Coordinator, who's here to share more about the resources available to employers like yourself. Hi, Sev.
Thank you, Anna. Hi, everyone. First of all, I want to thank you on behalf of City of Glendale's Economic Development Division for joining us today. We're very happy to be working with California Employers Association to bring you a webinar similar to this one today. But before we get into the main topic, I usually like to take a quick minute to talk about what we do here at Economic Development and how we can help either start or grow your business in Glendale. So our office really is responsible for and interested in 2 main things: business retention and business expansion in the city. And the way we approach those 2 goals is through our economic development services. So services such as finding a location for your business, assisting with the permitting process through our business concierge team, facilitating business resources and connecting you to local, state, and federal level of resources, promoting your business on our local social media and marketing outlets. And lastly, the most important one and relevant to today's topic is our free HR hotline available to all businesses in Glendale, specifically employers, through California Employers Association. So at any point, Monday through Friday, 8 a.m. to 5 p.m., you can give this number a phone call, the one that's on the screen right now, and get all of your HR-related questions and concerns figured out. So from basic ones such as what the minimum wage is, all the way to industry-specific ones. All of the services I mentioned are completely free, and if you'd like to utilize any of them, please contact me. I'll leave my information in chat right after this. I'll be more than happy to have a one-on-one conversation with every single one of you to see how our department can be of assistance in your business journey, whether you're an existing business or one that's interested in opening one in Glendale. With all of this being said, I will now pass the mic back to Anna to get the main portion of the webinar started for us. Thank you.
Awesome. Thank you, Sev, and your entire team over at Glendale for all that you do for employers in your area. So now I'd love to introduce our trainers today. We have Mary Bradford and Eli Nunez, 2 of our HR directors. So you're going to be in great hands. And I think I'm handing it over to Mary today.
Great. Thank you so much. Thanks for the introduction and welcome, everyone. Really glad that you're able to join us today to talk about a labor law update. We have a lot to get through in our quick hour together, so we're going to jump right into it. I did want to introduce CEA to you. If you are not familiar with our company, we are the California Employers Association, and we are the voice behind the hotline. So anytime you call, again, Monday through Friday, 8 to 5 on your hotline, you'll speak with one of the members of the HR team. You might chat with Eli, you might talk with me, or the other members of our HR advisor team. We do encourage you to call. It's a wonderful benefit that the City of Glendale is providing to you, so please make sure you take advantage of that. And again, call us with any of those HR questions you have. Now, if you need to know a little more about CEA, we are the company that is here to provide you with peace of mind, either through the hotline, or if you find you need a little extra assistance, we can help you with that, because we do want to provide you with HR solutions to try to make your life a little easier. Now, I do invite everyone to visit our website, which is employers.org. You can access all of our newsletters, all of our blogs, lots of great info out there. You can also access some of our HR forums, a lot of links to government forums, some of the things that we'll be talking about today. But if you find you might need a little more assistance, or you'd like to have full website access, that is outside of the HR hotline, but we have a slide at the end if you're interested in getting an individual membership with CEA so you can have full site access. Just give us a call and let us know. Now, you will notice there's a different phone number on the slides. I do just want to remind you to please call your designated hotline number for the City of Glendale, the 866 number. The 800 number that's on the slides that you'll see, that is our main CEA number, but we do ask that you call that hotline number just so we know where you're calling from. And then a real quick legal disclaimer, please keep in mind today's information, as well as any time that you call the hotline, we are providing information and education to you. We are not a law firm, so we can't give legal advice. And if you ever do need to get legal advice, we do recommend that you consult with an attorney. If you don't have an attorney and you need some that have been vetted, we do have several partners. You can find them on our website. They are all specialists in employment law, defending employers. So if that's something you need, again, just visit employers.org, click on the partners link, and it will get you there. All right, here's what we're going to cover today. We're going to talk about some of the executive orders that you might have heard of and how that's affecting you as an employer in California. I want to spend some time talking about I-9s and why it's so important you're following through with your process on your I-9s right now. We're going to talk about wage and hour updates. It's the middle of the year, so that means we're doing some wage and hour shuffling in California, so I want you to know about those. We're going to talk about a couple of cases that you need to know about, because again, when you call the hotline, and oftentimes people will say, have there been any cases on this, or what's the opinion on this? We often will cite case law because that gives us sometimes a direction of where we can take some of the more ambiguous California laws. So it helps us give you some direction on that. So we'll talk about those. And then a couple of summer reminders. I know we are right smack dab in the middle of summer, and there's lots of things to remember as we go through the second half of the year. So let's talk about how we want to be managing that I-9 process. One of the things we strongly encourage you to do is do an I-9 audit. Summertime is the perfect time to do this. It's the middle of the year. Maybe you had a busy hiring season in the first part of the year, or perhaps you're thinking of ramping up in the second half of the year. This is an excellent time to start the I-9 process, the I-9 audit process. There's a couple of unique things when it comes to California, so we're going to talk about that, and we'll talk about our executive orders. The first thing I want to tell you about, or remind you about, if you haven't had a chance to look at it lately, is there's something called the M274, which is a handbook for employers that the USCIS puts out. And that gives you a lot of direction on how you are supposed to fill out an I-9. It is very, very helpful, and it's a really user-friendly document. So I encourage you to take a look at that. Because as a reminder, you as an employer, you're required to have a I-9 form for every single employee who is working for you. And an I-9 form verifies an individual's identity as well as their ability to work in the US. So we want to make sure we've got an I-9 on file for each of our employees. There are some severe penalties if you are not complying with that. So we recommend, again, take a look. You want to start to do your audit. You want to find out, am I missing I-9s? Is it filled out properly? Have I done this correctly as you're looking at that process? So let's start with a real quick pop quiz on when you are supposed to fill out I-9s. And you can just use the chat box and you can drop in A, B, or C for this question. So you have a new employee who starts to work on Monday. So when is the deadline to complete their Form I-9? So remember, there's a section 1 for the employee to fill out and section 2 that you as the employer fill out. So tell me in the chat box, A, B, or C, should you have that form completely filled out on Monday, the day that they're starting to work for you? Do you need to have that filled out by Tuesday? Or do you need to have that filled out by Wednesday? I'm sorry, did I say Tuesday? Thursday. So Thursday within 3 business days or within 7 days. So let's see if you guys are all getting this right. But your quick answer here is Thursday. You need to make sure that you are filling that form out within 3 business days of hire. And I know sometimes it can get really busy because you're trying to bring somebody on and you just need them to start working right away. You want to make sure you're doing your due diligence for all of our new hire paperwork, including doing that Form I-9. Section 1 is the section that the employee fills out, and that actually needs to be filled out on their first day of pay. So the first day that you are paying them, they are filling out that section 1. You need to fill out section 2 within 3 business days. So make sure you're being very, very timely with that. Something else to keep in mind is we have a new I-9 form. They actually updated it in the past year or two, but we do have a brand new version or an updated version for 2025. The good news is they have simplified the I-9 quite a bit. They have put section 1 and section 2 into a single-sided sheet. Before, you might remember it was a 2-pager, but now it's a nice 1 single-sided sheet. It is now designed to be fillable. It can be filled out on tablets, mobile devices, etc. Some of the sections that were originally on the old form have been moved to supplemental sections. So they're separate documents, which means you just don't need to fill them out unless you actually need to fill them out. So you're really just primarily concerned with section 1 and section 2 in the majority of cases when you're having a new employee start for you. So section 1, which was that prepared translator certification, that's been moved. And the other section, re-verification and rehire, is now also a supplement B, if you ever need to re-verify an employee, if you rehire them, etc. So the current version date you're looking for is January 20th, 25, with an expiration date of 2027. It's possible you might have some old I-9s around the office that you're using for your employees to fill out, but we advise you start using that new form as quickly as possible. Technically, you are allowed to use an older I-9 version. There might be one that is from 2023 that perhaps you're using. If you weren't aware, there's a new 2025, but we recommend just go ahead and start using that new form. It's, again, much more user-friendly, and then you'll always be sure that you are using the most up-to-date form. You can always check for an expiration date. Those can be found on the upper right-hand corner of the I-9 form, so just make sure you are never using a form that's expired. And that's always why we recommend just go ahead and use the most up-to-date form. That's always a best practice for you. So let's talk a little bit about auditing I-9s and what you should do. So as you start to look at the I-9 process, what we recommend is you download a list of all of your employees with their hire dates. You can also and should also do it for terminated employees who've terminated in the past couple of years. So you put together your spreadsheet with the employee name, their hire date, termination date, if that applies, and then you're going to start looking through your I-9s, and you want to make sure, as a reminder too, that your I-9s are always kept in a separate folder. I-9 should not be kept in a personnel file. So you really want a standalone binder where you've got all of your I-9s so they're easy to access. You can look through them quickly. You keep your current employees in one section, your terminated employees in another section, so that you can kind of just monitor and audit that throughout the years. So as you start to go through your audit and you notice, oh, there's something missing or something's wrong, and you say, okay, what am I going to do for these I-9s? Well, we want to make sure that we are going to make any corrections that are necessary. And you might be thinking, should I use that I-9 form? Well, yes, if you're making corrections, you can use that I-9 form. But you do not have to redo I-9s for everybody. So just as you're doing your audit, if you're missing them, you're going to use that I-9. If you have an employee that already has an I-9 on file that's properly filled out, you do not need to do a new one. So keep those two things in mind as you're going through that I-9 process. Now, we get a couple of questions about remote verification. In the time of COVID, you might remember from a couple of years ago, if you were hiring new employees, you were able to remotely verify those documents. So that doesn't work anymore unless you are participating in E-Verify. So if you're participating in E-Verify, you are able to do a video. You can Zoom with somebody or Teams with someone to take a look at those documents over virtually or over the video to verify that information only if you're using the E-Verify system. For everybody else, you need to make sure that you are verifying those documents in person and you are physically inspecting those documents. So you as the employer or your authorized representative needs to make sure that you, again, are looking at those documents when you're filling out Section 2. There are some different rules in California, and that's something to keep in mind if you are referencing that M274 document, that handbook for employers about I-9. They're talking about the federal regulations. Keep in mind, California has some of their own regulations, and California actually prohibits the use of a notary public unless they are a registered bonded immigration consultant or a licensed attorney. So they have some stronger rules when it comes to who can verify those I-9 documents. So keep that in mind as you're going through that process. So continuing on with auditing our forms, as you start to go through all of those forms, you want to make sure that you get rid of any I-9 forms that you don't need to have. So remember, we always have an I-9 form on file for our current employees, but depending on how long they worked for you and how long it's been from their date of termination, you might not need to retain all of those I-9s when they no longer work for you. So we want to make sure we dispose of any of those. When it comes to correcting errors, don't make the mistake of trying to use whiteout or anything like that or rewriting it. You want to make sure you just very simply draw a line through the incorrect information and enter the correct information. You can initial it and then you want to date that correction. You can also attach the new I-9 form when you find those errors, fill out the appropriate section, keep both versions. So if you have an old one that you realize there was information missing or there was something that was inaccurate, just take the old one and the new one, staple them together, keep them so you can retain those files, and then make the appropriate corrections. We also recommend that you do some documentation to write down what the errors were, what the audit process was, just so you, again, have that paper trail and you've got that documentation. If you need some help with I-9 audits, give us a call. We would be happy to assist you with those. Now, you might have heard of something called an NOI, a notice of inspection. So keep in mind, you might receive a notice basically from ICE, or it could be another enforcement agency, and they are saying, we want to come take a look at your I-9. So that's why we recommend do an audit now. In the event that that happens, you as an employer need to make sure that you prepare and provide those forms within 72 hours of receiving that notice of inspection. You also need to make sure that you post a notice alerting your employees that there is going to be a notice of inspection of I-9. And then if you are notified that there's an issue with the employee's record, you need to provide that to the employee within 72 hours that this agency has found something. So keep in mind, this is why you want to be prepared. We have an amazing article that was recently written by Eli that you can see on our website that kind of takes you step by step through the process if you do have somebody come on site, if it's ICE or if it's another agency that comes on site. So take a look at that article if you have some concerns. We do also recommend that you consult with an attorney if that's something that you're worried about happening in your office, just so that you can be well prepared for that. All right, a couple of other reminders on I-9. Make sure that you are following the process and you've got an I-9 on file for everyone that's properly filled out. Make sure that you are auditing them annually, or if you're a big company, it might be something you want to do twice a year if you have a lot of turnover, just so you can make sure that you're staying on top of it. Be prepared if you do learn of a notice of inspection that's coming, and just so you can be prepared to provide the appropriate documentation and respond appropriately to that. For those of you that are CEA members, we do have an I-9 audit toolkit. Hopefully you're familiar with all of our toolkits. They're really amazing resource guides that take you step by step through a lot of these processes that you have to deal with. So take a look at those. And again, if you need help with an I-9 audit, just give us a call and let us know. We'd be happy to help you on that. So let's talk a little bit about DEI. You might have heard that there were some executive orders that came out that kind of changed DEI. It's certainly been on the national news, and we want to talk about how it's going to affect you in California as well. So if you're not familiar with DEI, diversity, equity, and inclusion, it's something that's been around for several generations. But in the past couple of years, the past decade or so, it really started to get a lot more attention, and you started to hear a lot about DEI programs and DEI training, et cetera. So the new executive orders have had a little bit of an impact on what that means in California, but kind of a bigger impact at the federal level. But let's talk about kind of how it's affecting you here in California, what you need to know about. So this first executive order, which is the 14173, called Ending Illegal Discrimination and Restoring Merit-Based Opportunity. So what this executive order was saying that it's possible that some DEI programs were causing discriminatory preferences that actually violated civil rights law. It revoked federal contractor and subcontractor affirmative action requirements. So you might have heard that there have been changes to affirmative action because of these executive orders. And it also required the Attorney General to provide recommendations if they found that there were illegal DEI programs that were going on. So specifically, the plan is to target larger companies, nonprofits that might not be following the guidelines when it comes to DEI. So we have included a link, it's a bit.ly that you can see on this slide. If you're not familiar with a bit.ly, it's just an easier way to find a web page. And this provides some of the EEOC guidance, that's the Equal Employment Opportunity Commission, on DEI-related discrimination. So if that's something that you're concerned about, you can take a look at the EEOC guidance. That will give you some more information on that. So a question that we've received is, did this new executive order make DEI illegal? Because that was often being said. And it's not that it's making DEI illegal, because it's not changing the discrimination laws that we already have in place. But because keep in mind, of course, making decisions that are based on a protected characteristic, whether part of DEI or not, that has always been illegal. As you're probably familiar, in California, we have a lot more protected characteristics than they do at the federal level, which is why this is a little different for our California employers. But the reality is some employers who have DEI programs may come under a little more attention, a little more scrutiny, especially these large corporations, which is why you've probably heard many corporations have done away with DEI programs, or they've kind of revised some DEI programs. So just remember, we always want to make sure that we have a diverse and inclusive workplace. We want to make sure that we're always looking out for our employees, regardless of any protected characteristic that they fall under. We do need to make sure as employers, though, that we're not giving preferential treatment based on race, sex, or any other protected classes. So if you had a practice in the past where you said, I want this particular person in this role or this particular person in that role, that's going to fall under some scrutiny. So we have to be careful with that. Same thing as it comes to quotas. We need to make sure that we're not doing that. And you also don't want to give points to applicants for certain protected groups unless that's mandated by law. There are some groups that can receive some particular points, especially when it comes to veteran applicants. There are some carve-outs for that. But in general, we want to make sure that we are not making any decision based on any of these protected categories. So this is your reminder that we want to update job descriptions all the time. You want to make sure that you have well-written job descriptions for all of your positions that focus on the essential functions, what are the qualifications, the education, the background, etc., that your ideal candidate should have for that position. So in addition to doing your I-9 audit, we would recommend that you also do a job description audit so you can make sure that your practices, again, are compliant and are staying up to date with some of these law changes. The other executive order you might have heard about is Defending Women from Gender Ideology Extremism and Restoring Biological Truth to the Federal Government. This is one that also got a lot of attention in the news. It's saying that the federal government only recognizes two sexes, male and female. And again, that's based on a biological classification. It rejects the interpretation of the Supreme Court rulings, including sexual orientation and gender identity in those Title VII protections. And this is one that I think has received the most attention in California because this is a little bit in conflict with what we have under FEHA, which is California's Fair Employment Housing Act. In California, under FEHA, gender identity and gender expression are protected classes. And for those of you that have attended harassment prevention training, that is required to be part of the training, that those are indeed protected classes and what those particular definitions mean. So FEHA says that employees have a right to use a restroom or locker room that they identify with as far as their gender, and they need to be addressed by the name and the pronouns of which the gender that they identify or as they're expressing themselves. So keep in mind, California does still have some changes or protections in place that are different than the changes going on at a federal level. So make sure that you are complying with both of those. And remember, if something is more protective of the employee, as many things often are in California, we're always following that guidance. So a couple of DEI reminders and things to do. Make sure you take a look at your hiring, your internal policies to make sure that there's not a preferential treatment for a certain group, any of those protected classes. You want to make sure, again, when you do job descriptions, when you do job postings, that all of those postings are based on the requirements for the position and it's not singling out a certain group. Remember too to train hiring managers, recruiters, especially, I know many of you might have multiple locations. You want to make sure that everybody is following those appropriate guidelines and being consistent in your hiring process. And of course, keep monitoring for federal updates. Things change. I'm sure you will often hear that there's an injunction against something or something is being sued or changed. So that's why I encourage you stay up to date with our blog, with our newsletter, because we'll certainly let you know when any of those changes are coming through that you need to be aware of. All right, so let's take a breath and we will start to talk about wage and hour updates, which is probably what you're most worried about, managing wage and hour here in California. We do have some July 1st changes that you need to know about, a couple of industry specific things, especially for those of you in healthcare area or in fast food. I know there have been a lot of changes for you in the past year. We have a really nice pro-employer case that I will share with you. And then we're going to talk about, yes, another audit suggestion for you when it comes to wage and hour. So as a reminder, right now, California's state minimum wage is $16.50 an hour for our non-exempt hourly employees. So that means every employee needs to be making at least $16.50 an hour when they are working for you. The reason we want to take a look at what the state minimum wage is because that affects what our salary or our exempt employees need to receive annually as far as their compensation. So right now, all exempt employees need to make a minimum of $68,640 a year. Now, as of right now, we have not heard about 2026 changes yet, so stay tuned. Often that comes out later in the summer. So again, another reason to make sure you're staying up to date with our newsletter and our blog. But as of right now, this is what we have to manage in California at a minimum. So $16.50 for our hourly, $68,640 for our exempt or our salaried employees. If you're thinking, gosh, it's too hard to manage these exempt employees, I'm going to change them to non-exempt or I'm not going to be able to keep up if there is another salary increase, we've actually put together kind of a guideline cheat sheet for you if you do need to change any of your employees from exempt to non-exempt. Remember, in California, you can always change an exempt employee to non-exempt because basically everyone defaults to being a non-exempt hourly employee, and it's up to you to show that they should be something different. So if you're just thinking, you know what, I'm going to make it easier, I'm just going to transition my employees to non-exempt, yes, you can absolutely do that. And that's why we put that guide together for you, because we had so many businesses that did decide, let's just make people hourly. It's a little easier to manage and a little easier to keep up with some of those salary changes. Now, I would love to tell you that's the only salary you have to work about, but you are located in Glendale. So you know in your area, there are a lot of different minimum wages. There's over 40 different local minimum wages in California now, specifically in Southern California, as well as the Bay Area. And remember, we need to make sure we are always paying the appropriate minimum wage based on where that employee is physically working. So if they are working from home, if they're working remotely, we need to check that minimum wage. If they're traveling and working at multiple locations and receive minimum wage, you need to check each of those cities to find out if they have a different minimum wage and that you need to pay that. So we have put together another bit.ly for you on this slide, a nice summary of California's minimum wages as well as our paid sick leave requirements. Yes, there have been increases as of July 1st. There are several cities that do mid-year increases. We also have a lot of cities that do January 1st increases and a couple of cities that have done April 1st increases. As of now, I don't believe we have any October 1st increases, but I'm sure someone will want to try that one of these days. So take a look at our fact sheet that we put together for you. Make sure you're staying up to date on that so that you can adjust any of those hourly salaries appropriately. For those of you in the fast food industry, you are probably painfully aware about changes that have happened when it comes to minimum wage. You might remember from last year, April of last year, for individuals who work at a fast food establishment, or as they're known, limited service restaurants, with 60 or more locations nationally, have to comply with this fast food minimum wage that was set up by the Fast Food Council. So currently that is $20 an hour that your fast food workers need to receive. Now, when it comes to your exempt employees, they need to be making $83,200 a year if they're exempt. So perhaps a manager, a higher level position that's classified as exempt for fast food. We have not heard about a change yet when it comes to our fast food friends, but I would keep your ears open because there could be something coming down the pike soon. So as of right now, we're still at the same level, but stay tuned. It possibly will change in 2026. So far, we haven't heard about a change. When it comes to healthcare, boy, this has been a tricky one to keep tabs on and to also be able to understand because they went back and forth and there's different categories as to what kind of healthcare organization you're in. So this is one where we would say, take a look at the information on it. Again, we've got a bit.ly for you on this slide, but this is probably where you're going to want to consult with an attorney to make sure that you are classifying your employees correctly. So this actually went into effect last year, at the end of last year, October 16th. There was an increase that just went into effect July 1st. So this is why you have to really stay up to date on this. There are, as I mentioned before, different categories based on how many doctors you might have, what type of facility you are. And so there's different ranges of pay that go from $18 to $23 an hour. Also, there's another change when it comes to exempt employees in this healthcare industry, if this applies to you. They have to be paid 1 1/2 times the healthcare minimum wage or 2 times California's minimum wage, whichever is greater. So again, kind of a lot of parts to this. So you want to make sure you're following along with this and stay up to date. There will be more changes over the next 6 months into next year. So stay up to date on those changes and visit our FAQs that are available for you to take a look at. I'm sorry, that's actually the state's FAQs. That's not CEA's. So visit that website if that applies to you in your industry. So let's talk a little bit about meal breaks and kind of reminders when it comes to meal breaks. I would say, I'm sure of all the things that keep you up at night, meal breaks and rest breaks and overtime are probably at the top of that list. And there have been some changes with meal breaks that we wanted to talk with you about. But as a reminder, you want to make sure that you are providing your employees an uninterrupted minimum 30-minute meal period anytime they're working more than 5 hours in a day. If they're working between 5 and 10 hours a day, they get one unpaid 30-minute meal period, unless 6 hours will complete their day. And that's when we're going to talk about meal waivers in just a second and why that has changed. But before we get to there, let's finish up with our meal breaks. So between 5 and 10, they're going to get one 30-minute unpaid meal break. If they're working over 10 hours, they're entitled to 2 uninterrupted, unpaid 30-minute meal breaks. If their total workday is no more than 12 hours and the employee took their first meal break, they may waive that second meal break. So again, if you have employees that are working, let's say, for example, an average 8-hour day, they're going to be entitled to one 30-minute meal period. If 6 hours will complete their day, they may, by mutual consent, waive that meal period. So you as the employer and they as the employee agree, say, you know what, I'm only working 6 hours, I'm going to waive that meal period. So you are allowed to waive that. Same thing for your employees who are working longer shifts. If they're working more than 10 hours, but no more than 12, they can agree to waive that second meal break as long as they took their first meal break. So let's talk about waivers. So say, for example, you present all of your new hires who might work shifts of 6 hours or less, or perhaps as longer shifts, with a voluntary meal break waiver to sign at the time of onboarding. So when they first start working for you, you say, hey, go ahead and sign this waiver. If 6 hours completes your day, then you're okay with waiving that meal period. So is it okay to do that, or is it okay to keep doing that? Yes, it is. And here's the good news. We've got a very nice court case on it. Because in the past, it was assumed it was okay to do that. But now we've got a meal break case saying, absolutely, you can do this. So employees can sign off in advance, even before they've ever taken a meal break or had a meal that they need to waive. It can just be part of your new hire process. You provide them a copy of a meal break waiver form. They can fill it out. And then when they work 6 hours or less, they then have that waiver on file. Keep in mind, the waiver needs to be on file. It needs to be in writing. It should be signed by both parties, the employer and the employee. They can revoke it as well as you as the employer. So either party can revoke that meal waiver, and we can't retaliate against an employee who says, you know what, I signed that 6-hour meal break waiver, but I really need to take a meal period today. You can't write them up. You can't discipline. You just say, okay, no problem. You're entitled to that meal break. We'll make sure you get a meal break for today. Also, make sure that you train your supervisors. Remind, again, if you have multiple shifts, multiple locations, make sure everybody is on the same page with this, and remind your supervisors, your lead, your foreman, whoever it is, that, hey, if an employee says, I know I have a meal waiver on file, but I want to take a meal waiver today, or a meal break today, excuse me, that you need to make sure you allow them to do that, and they don't take any adverse action against them for doing that. Now, the other big change when it comes to wage and hour is something called PAGA and PAGA reform. So PAGA stands for the Private Attorneys General Act. It's probably something you've heard about in the past couple of years. The good news is they have done some reform because it was becoming quite costly for a lot of employers. And what this reform is saying, that employers now have opportunities for you to reduce your potential penalties if you are cited in a PAGA claim, if you can show that you took reasonable steps to comply with wage and hour laws. So what are some of those reasonable steps? Here's your audit opportunity again. You need to be auditing your payroll records. You need to be auditing your policies. You need to be training your supervisors, training your managers, reminding them about meal breaks, meal break waivers, checking time cards to make sure that they're filled out accurately when there are corrections or adjustments that need to be made, that both parties are signing off and approving those. Those are all of those things that you can do to show that, hey, as soon as we found out there was an error in our wage and hour process or in our rest breaks or in our time cards, we corrected them. And this is where you want to document. Anytime you're doing an audit, all the time that you are training your supervisors and managers on wage and hour, make sure you are documenting that. So you've got a paper trail to show you are trying to take those reasonable steps to kind of cure or correct those issues that are going on in the workplace. Also, you need to make sure that you take corrective actions for any of your supervisors who aren't following your policies, who aren't doing the proper things. Make sure, again, you're being proactive, you're training. If things aren't going well, you are correcting and taking appropriate action. We do have a really nice, excuse me, wage and hour audit package that we've put together on this that you are able to purchase even if you are not a CEA member. And that is on our CEA store at employers.org. So you can do this in your own business. You can make sure that you're taking the appropriate steps to audit these things. We also have a really nice PowerPoint training that will train your supervisors. So again, you can show that you're doing everything you can to make sure everybody's on the same page and following the guidelines. So a couple of to-dos, reminders here when it comes to wage and hour. Keep an eye on those minimum wage rates. Again, look at all the different cities where your employees might be working, where you have locations, or where they might be working remotely. Take a look to adjust salaries for your exempt employees as appropriate. Remember, the good news is we have the state minimum salary requirement that is based off of the state minimum wage. That does not change if they are in a city that has a higher minimum wage. So the good news is you can always follow the state minimum salary requirement for your exempt employees, but keep an eye, especially for January, if our minimum wage goes up, our exempt salary will go up. So be mindful of that. Make sure you're taking a look at your meal period waiver process. And again, training your managers and supervisors on meal breaks as well as rest breaks to make sure that they are being compliant with that. And then put in place those reasonable steps. So do your wage and hour audit, keep track of everything that you're doing to correct if you find out there are any errors, so that you can show if for some reason you get a PAGA lawsuit or a PAGA notice that you are trying to fix these issues that you found and that you have corrected them. So again, wage and hour audit, PAGA prevention package is available for you on that CEA store. So take a look if that's something you need to worry about. So let's spend a couple of minutes talking about some employee rights. We've got some AI changes since everyone's dealing with AI these days, reasonable accommodation, and of course, a couple of reminders about employee posters and notices that are something that you need to be mindful of not only in January, but throughout the year. So CRD is the California Civil Rights Department. That used to be the Department of Fair Employment Housing. It is now known as the Civil Rights Department, or the CRD. Just this past March, they put out some regulations regarding being careful with the use of AI so that it doesn't cause a potential discrimination issue when it comes to personnel decisions, specifically screening applicants, doing checks on applicants, etc. So what they are saying, and this will go into effect October 1st, we would certainly recommend you put these practices into place as soon as possible. But when it comes to some of those automated decision-making systems, so AI, machine learning, other data processing systems using statistics, that you are very careful while using those, because some AI tools can result in adverse impact discrimination, and that's what you want to avoid. We have to make sure that we are not just using AI to make decisions when it comes to applicants. We need to be careful and ensure that we are having the human touch, that we are looking at applications, that we are looking at test results, that we are looking at any of those tools that you might be using and you're not using AI alone. So be very careful with that, especially when it comes to criminal history. You as an employer, if there is something that comes back on a background check, for example, need to do an individualized assessment. You need to do that, not just AI. So be very cautious that you're not letting AI make all the decisions for you, and you still have that human touch when you're reviewing these things. Keep in mind, if you are using any AI-related records, falls under the record retention requirements, which are 4 years, which is kind of the general guide when it comes to applications, for example, personnel files, post-termination, etc. 4 years, you want to hold on to any of those documents. Switching over to leaves of absence, I'm sure many of you have been dealing with leave of absence issues. We have tons of calls lately on the hotline about leave of absence issues, but here is another pro-employer case that recently came out. So there was a situation where an employee had exhausted their family and medical leave. So that can be CFRA, the California Family Rights Act, or FEMLA, the Federal Family Medical Leave Act. And they had exhausted all of that time. They then requested additional time off. They asked for more unpaid leave, and there were multiple extensions. The employer, which in this situation was the J. Paul Getty Trust, they tried to go into what's known as that interactive process, which is what we always recommend you do as an employer, where you say to the employee, can you come back part-time? Can you come back a couple days a week? If you come back, are there certain modifications or restrictions you might have? They were trying to be very proactive in trying to get this individual back to work. They continued to grant these leave of absences requests that kept going on for about a year. Finally, They denied the last request that the employee gave them because it was indefinite. It didn't have an end date. It didn't have a expected to return to work date, etc. And they terminated the employee again after they followed up with them to ask for other accommodations. So it went to court. The good news is the court ruled in the employer of the favor. They said, or excuse me, went in the favor of the employer. They said the employer had done a really good job of interacting with the individual, trying to get him back to work. Again, part of that interactive process. They granted them repeated requests for the unpaid leave, again, up to a year. They reached out to the employee, they stayed in touch. So here's a reminder, anytime you have an employee who's out on leave, yes, you are able to check in with them. You are able to ask for another note if their note has expired. You're able to keep up with, again, that interactive process. But keep in mind, there is not a hard and fast rule as to how long you need to keep an employee on an extended leave of absence. In this particular situation, it was about a year, but that doesn't mean after a year you can just automatically cut somebody off. What you need to do is make sure you're always checking in with that employee. You're finding out if there's a change to their work status. Are they able to come back? Again, when a note expires, you're asking for another note. You are allowed to do that. And the other thing we recommend, it's not a bad idea to consult with counsel if you are deciding that you need to terminate an individual in those situations. Sometimes it's really good just to talk to an attorney, get a second opinion, see what they think before you do that termination for these extended leaves. Another reminder when it comes to labor law posters, as you all should remember, you need to make sure every January you have a new labor law poster that includes the federal as well as all of the state postings. We have a couple of updates. We just have a brand new crime victims notice that came out. That was due July 1st. It came out just about July 1st, but you want to make sure that you distribute that now to all of your employees. You also want to make sure you provide that notice for your new hires. So moving forward, anyone that you bring on. And then upon request, anytime an employee asks to get a copy of it, or anytime you're informed from the employee that they or one of their family members was a victim of crime, you want to give them a new notice for that. We're also expecting some other updates from the EEOC based on some of those executive orders that we talked about today. California minimum wage postings, if you are in a city that has a new minimum wage, as of July 1st, you want to make sure that you've got the new posting up. When it comes to if you're in healthcare and fast food, anytime those salaries change, you want to make sure you've got those new posters up as well. If you don't have a 2025 labor law poster already, you can order one on our store. It'll be shipped right to you. We also can get those to you in multiple languages if that's something that you need. So a couple of to-dos when it comes to employee rights. Again, take a look if you're using AI for part of that applicant screening. Make sure that you are using it properly and that you are holding on to any of those records for 4 years. Talk to your staff about the proper use of AI and how you want them to manage it as well when it comes to working with your employees or with your applicants. Remember to talk to your managers and always train your managers on how leave of absence requests should be handled. Oftentimes managers or supervisors don't know what they're supposed to do. They might have somebody call in who's on a leave and they'll say, I'm going to be out 2 more months. And the manager goes, okay, assuming that maybe that employee has talked to HR or HR is in the loop. Oftentimes they're not. So make sure you remind them anytime you get a leave request, anytime somebody wants to extend a leave out or something's going on, they need to talk to you, to HR, next level of management, whatever's appropriate for you. Keep an eye out for those posters. We do have that new crime victims notice that is now out, just came out a couple of days ago if you need that. And for those of you that are CEA members, we do have a sample AI policy that's on our HR forms page. You can access that. Just, of course, make sure you're logged in to any of the member-only benefits so you can see those. All right, with our last couple of minutes together, I want to do just a couple of summer reminders for you. We do have heat illness protections in place, workplace violence prevention plan, that's sometimes known as WVPP. This is the time of year you want to do training again. And then we'll talk about CalSavers. So let's jump in with indoor heat illness. This is something that was new last year. It started last year. And so this is our first for our second, but our first full summer of indoor heat illness. Keep in mind, this applies to businesses that have indoor work areas where the temperatures might reach 82 degrees or more when employees are present. So this could be a warehouse, for example, manufacturing, some kitchens where they don't have full AC. But if you are in an enclosed building where it's always temperature controlled and it never gets above 82 degrees, this doesn't apply to you. But if you are in an industry or a business that does have areas that could get over 82 degrees, then this is absolutely going to apply to you. Even if you are thinking, well, this probably doesn't apply to me, keep in mind as part of your injury illness prevention plan, you should have some guidelines on what to do if the AC breaks, or some policies or practices on how long your employees will stay there and continue to work if utilities go down, AC goes down, anything like that can sometimes happen in the summer. For those of you that have outdoor operations, you're probably already very familiar with the outdoor heat illness standards that we already have. The good news is they are somewhat similar. So if you're dealing with indoor and outdoor heat illness, then you're probably familiar with those plans, and it will be fairly easy for you to put this together. We do have a fact sheet. We have a lot of resources. The state of California has also put together some great resources for this if you need that. A couple of reminders, you just want to make sure that you're providing your employees with water, with cool down areas so they have some shade. What you should do if somebody is having a tough time, heat stroke, etc. You want to make sure you've got those in place. So this is your HIP plan, your heat illness prevention plan. And you want to make sure you train your supervisors, your managers, etc. And there's different requirements based on your industry. So if this applies to you, take a look into it and make sure you've got up-to-date plans, especially since that one's the indoor is pretty new from last year. When it comes to workplace violence prevention plan, remember this went into effect last year. So July 1st of 2024, this was required, and it is required for you to keep up to date with your workplace violence prevention plan. So you need to make sure that you are doing an annual review of your WVPP. You should be asking your employees every year if they have any questions or want to provide feedback on your WVPP. You need to have annual training. So you talk to your employees about any changes that you've made to the plan, or if there have been incidents or issues and changes that you've made because of that. You also want to make sure you're doing periodic hazard inspections and your safety meetings. We do have a workplace violence prevention plan package, say it 3 times fast, available for you on our website. So if that's something you haven't put together, don't beat yourself up too much, but do it as quickly as you can, because this is something you are required to have in California. So visit our website, download that, and you will be well on your way for compliance with that. Another reminder about CalSavers. Keep in mind, CalSavers is for employers who do not have a retirement plan. This has been around for a couple of years. It started with larger employers, and then every couple of years it would apply to employers with fewer and fewer employees. But now it's going to apply to absolutely every employer who does not have a 401k plan. So by the end of this year, if you have 1 or more employees and you do not have some sort of retirement plan, you are required to register with CalSavers, which is a retirement savings program that the state of California has put together. You, as an employer, do need to register again. If you do not have a retirement plan, you need to register with them. You're going to provide them with the employee info, and then it's entirely up to the employee if they want to participate. It is a voluntary program, but you do need to make sure that you get registered if you don't have a retirement plan. If you already do have a retirement plan in place, you do not have to worry about this. It's only for employers who don't offer retirement plan savings for their employees. So here's your to-do list. Make sure you're complying with the workplace violence prevention plan. You're going to do that training again this summer if you haven't done it yet this year. You're going to also develop your heat illness prevention plan, indoor and/or outdoor, depending on your industry. And for those of you that don't offer a retirement plan, you want to make sure that you register with CalSavers by the end of the year if you have 1 or more employees. We do have a couple of safety partners if you need assistance with your workplace violence prevention plan. If you're in a high-risk industry, they can assist you with that. They can also assist you indoor-outdoor heat illness if you need some help with that. So I encourage you, reach out to them. they could be a great resource for you. All right, so what's next and what do you have to worry about for the rest of the year? You just want to remember, you've got to stay up to date on all of these trainings. As I mentioned, Workplace Violence Prevention Plan, that was supposed to happen July 1st. If it hasn't happened, make sure you're doing that this summer. You also want to remember you need to keep your employees up to date on their harassment prevention training. Remember, that's every 2 years. Your non-supervisors need an hour of training. Your supervisors need 2 hours of training. We also encourage you train your supervisors, your managers, your leads on wage and hour. We do have a package available for you. I know that Anna dropped that into the chat box. If that's something that you need, we are continuing to see lots of issues with rest breaks, meal breaks, etc. So make sure your managers are trained on that. You also want to make sure your handbook is up to date. If you have not updated your handbook for 2025, I think based on everything we've talked about today, you probably realize your handbook is out of date. So make sure you are keeping your handbook up to date. We do have a DIY handbook template that is on the website that you can purchase if you need to do that, or we can help you out putting together a customized handbook if you need that. Keep an eye on all of those wage requirements, the minimum wage that just went up July 1st for certain industries or different cities that you might have employees in. You also want to make sure you've got a labor law poster for 2025. Keep in mind, if you don't have that posted in the workplace and Cal OSHA comes in, the fines are several $1,000s. So that is a cheap investment to avoid a big fine. Stay tuned. Join us later on this year in December. We will have the 2026 labor law update for you to talk about what's coming up for next year. But just try to stay up to date with us. We've got great emails. We've got a great newsletter, our blog. Those are all available for free for you on our website. So stay tuned for changes that are coming up and keep up to date on those, because as you know, it is always changing here in California. And again, if you find that you need a little more assistance and you'd like us to come on site or you'd like us to put together a handbook for you, just let us know. You can join as an individual member so you get that full website access, all of our toolkits. We're happy to help you out with that. And then we have your hotline number here for you again. Make sure that you're giving us a call anytime you have questions. We always enjoy chatting with you. That's 888-248-3074. And with that, I'm going to turn it over to Anna. Thank you, Eli, for handling all those questions, because I know that was a lot of information. And thank you, everybody. We'll look forward to talking with you again soon.
Love it. Thank you, Mary. Thank you, Eli, for sharing your time and expertise with us. Thank you all for such insightful questions in the chat and Q&A. I saw that all flying in, and thank you, Eli, for addressing those. As I mentioned at the top of the hour, we do have a very brief survey. This allows us to hopefully, better serve you with trainings like these. So if you can either scan the QR code there, or I'm actually going to drop a link into the chat as well for your convenience. That will allow you to also kind of share your feedback on what you'd like to see in the future. If you are joining us for continuing education credits today, give me a moment here to grab those. There we go. HRCI code today, 710036, SHRM code 25-RU77E. If you need a little guidance on what to do with these codes and you are eligible for certification, please just shoot us an email, ceainfo@employers.org, or always call that complimentary HR hotline provided by the City of Glendale. Speaking of, I don't know if Seb, if you're still